Good day, everyone. Thank you for joining us today. In this presentation, we will discuss the H-1B visa program and its advantages for hiring foreign nurses. We will also explore the concept of the H-1B RN position as a specialty occupation and how hospitals can prove the qualification. By the end of this session, you will have a better understanding of why the H-1B visa may be a viable option for your hospital's staffing needs and how to establish the specialty occupation requirement. For the past decade, our primary vehicle to bring nurses to the U.S. was the EB-3 Green Card visa. It was reliable, effective, and suited the needs of the healthcare industry. But times change and so do visa strategies. The EB-3 Green Card visa has been a popular choice, as the standard education requirement for an RN has been recognized as an associate's degree. This pathway allowed many nurses to land on U.S. shores within 12 to 15 months, a time frame relatively quicker than others. Think of EB-3 like a superhighway. It's fast, reliable, and the go-to for a long time. But in April, we hit a roadblock: retrogression. This backlog is expected to stretch well into 2024, making it imperative for us to seek alternatives. This brings us to the H-1B visa. This visa strategy presents two main advantages. Firstly, it significantly reduces the processing timeline compared to the EB-3 Green Card. Secondly, VisaMadeEZ has successfully secured approvals for a number of H-1B RN cases, with many more in progress. For those new to the H-1B, here's a primer. It's a work visa, temporary in nature, allowing foreign nationals to work in specialized occupations in the U.S. There's a catch, though. These roles require at least a bachelor's degree. Each year, there's an 85,000 visa cap, reset every U.S. fiscal year. Prospective employees must participate in a registration lottery, known as the H-1B cap, each March. If chosen, they can commence work by October 1. Now the thrilling part: hospitals and staffing companies who meet our outlined criteria can bypass the H-1B cap, enabling them to recruit RN all year round without being bound by the 85,000 limits. Let's delve deeper into the timeline I alluded to earlier. As you can observe here, we've mapped out each step associated with both the H-1B and EB-3 visa processes. When dealing with the H-1B process, after filing the case, we typically receive an approval in about 15 days. For those acquainted with the I-140 premium process, you know that this turnaround is similar, with approvals usually within that same 15-day window. On obtaining approval via the EB-3 process, the usual progression leads us to the National Visa Center, or NVC, followed eventually by the consulate interview. However, and here's the silver lining with the H-1B process, we get to sidestep the NVC phase, proceeding directly to the consulate interview. This streamlining is precisely why we're advocating for the H-1B for RN. Currently, filing an EB-3 Green Card could make one wait an estimated 18 to 24 months for a nurse to set foot on U.S. soil, primarily due to retrogression. Contrastingly, with the H-1B, we've managed to condense this lengthy process to a mere 3 to 5 months. A vast improvement, wouldn't you agree? In essence, the only variability in these few months hinges on how swiftly appointments can be scheduled and how efficiently the Department of State processes visas. Let's transition to the next topic. I'll guide you through the necessary standards for securing an RN H-1B visa. We'll be discussing 3 essential criteria for acquiring an RN H-1B. Firstly, the RN must fulfill the job requirements, which I'll elaborate on shortly. Secondly, the job role offered by the employer must necessitate a bachelor's degree. Lastly, while ensuring the position mandates a bachelor's degree establishes a valid H-1B, it's crucial to remember the H-1B cap constraints. This cap sets a limit of 85,000 visas and restricts the H-1B commencement to October 1. Let's start with the criteria for RN beneficiaries. The RN must hold a bachelor's degree or its equivalent, specifically in nursing, meaning a BSN. In most instances, we support our H-1B application with a copy of their diploma, which is verified by a U.S. agency we collaborate with. This agency assures immigration that the applicant's academic credentials match the U.S. nursing bachelor standards. Typically, this is a smooth process. Next, the RN must possess a valid license in the state where they intend to work. I understand that the time frame for acquiring a license can differ by state. However, from my interactions with clients, I've observed that nurses with a license from another state can expedite their licensing in a new state through endorsement, making the process more efficient. I know some may wonder about the challenges in securing a state license, especially if there is a stipulation like a social security number. The silver lining here is that you can obtain a 1-year H-1B if a technicality like this prevents the license. In such instances, a letter from the state nursing board stating the RN has met all requirements except for something like a social security number can be included in our H-1B application. Lastly, let's touch upon the healthcare worker certificate. This is a must-have for anyone entering the U.S. as a healthcare professional. Commonly known as a visa screen, this certification, provided by entities like CGFNS or also known as the Commission on Graduates of Foreign Nursing Schools, which confirms the healthcare workers' qualifications in 3 areas: education, licensure, and English proficiency. There's a nuance here. If the RN is outside the U.S., the certificate is only needed at their H-1B visa interview. This allows for parallel processing. However, for RN already in the U.S., say on an F-1 student visa, the certificate must accompany their H-1B application. It's essential to bear this distinction in mind, as the absence of this certificate for U.S.-based RN can delay the H-1B application process. Let's move on to the employer position requirements. As previously noted, the H-1B RN role is classified as a specialty occupation. So, what exactly does specialty occupation mean? Simply put, it's a job for which a bachelor's degree or an equivalent qualification is typically needed. The Department of Labor publishes the Occupational Outlook Handbook OOH. This handbook outlines various job roles and the academic and professional qualifications deemed necessary by the Department of Labor, ranging from entry-level to the more advanced positions. Historically, RN weren't often targeted for H-1B roles since the OOH indicated that the usual minimal educational requirement for RN was an associate's degree. This meant that an RN could obtain a license in nearly every state with just an associate's degree, making the H-1B visa less relevant for RN roles. However, the OOH has recently been updated to acknowledge 3 primary educational pathways for RN licensure: an associate's degree, a diploma, or a bachelor's degree. It's been recognized in the OOH that many healthcare facilities now prefer or mandate a bachelor's degree for RN roles. Furthermore, in 2015, USCIS released a memo addressing H-1B eligibility for RN roles, signifying them as specialty occupations. This memo underscored that there had been considerable shifts in nursing industry standards over the previous 12 years. Now, almost a decade since that memo, the landscape of nursing continues to evolve. Given these shifts recognized by both the Department of Labor and USCIS, coupled with ongoing changes in industry standards, we developed a revamped approach to this matter that has shown promising results. Let's proceed to the next slide. How can organizations convincingly demonstrate a specialty occupation to the USCIS? The first method, albeit the most straightforward and probably least frequent, is for a hospital or healthcare system to have a consistent policy where all RN must possess a bachelor's degree. While it's a rarity if such a requirement exists, it simplifies the case. However, our primary focus is on a more nuanced approach. We're emphasizing particular departments, divisions, or groups where there is a distinct need for nurses with bachelor's degrees. This might not apply to every nurse in the institution, but specific roles or departments would necessitate it. For instance, based on the 2015 memo, certain specialties like critical care, cardiovascular, perioperative oncology, and more are highlighted. It's not about mandating a bachelor's degree for an entire department, but ensuring particular essential roles within that department need it. The core of this argument revolves around the specific needs defined by the employer. Perhaps it's advanced roles requiring unique skills that not every RN possesses immediately upon hiring. Maybe the hospital requires someone for immediate deployment, such as in a float pool situation, demanding nurses with a higher educational background and experience. Alternatively, it could be long-term placements to fill persistent gaps or roles catering to specific patient types demanding advanced expertise. Now, let's talk about how we prove and provide types of these evidence. Here are a few examples of how we substantiate these claims. We're positing that certain departments or work groups necessitate a bachelor's degree. When we bring this to the USCIS's attention, they'll naturally challenge us. You assert a bachelor's degree requirement, but how do you verify that? A cornerstone of our evidence rests on showcasing the academic credentials of current members within the designated group. Hospitals or health systems that have established this criterion will, of course, have staff members who aren't H-1B holders but meet the bachelor's benchmark. Providing copies of their degrees and transcripts, or having HR personnel verify and confirm these qualifications. Another essential piece of evidence is a comprehensive job description. While general RN roles exist across different departments, bachelor's qualified nurses have unique tasks. They undertake specific duties that aren't customary for other nurses. Moreover, pointing to consistent job postings that specifically seek bachelor's qualified nurses further underscores the employer's genuine requirements. Wage disparities also offer compelling evidence. Depending on the role's requirements, including additional certifications or experience beyond the bachelor's degree, these specialized RN are likely to earn a higher wage than entry-level counterparts, aligning with the Department of Labor's OES guidelines. Furthermore, any mandated clinical or advanced certifications, whether by the state or the medical group, emphasize the specialized nature of these roles. Likewise, if there are experience prerequisites beyond what an entry-level nurse might have, it's another testament to the role's specialized nature. An additional consideration could be facility-wide recognitions, such as the magnet-recognized status mentioned in the 2015 memo, highlighting the elevated standards. To sum it up, this provides a comprehensive view of the specialty occupation stipulation, what the RN role should manifest, and the supporting evidence an employer should present to the USCIS. Now, let's transition to discuss the topic of CAP-exempt status. I've already touched upon the benefits, and it's definitely an exciting prospect for employers who can qualify. So, I do want to put out there that it tends to be a pretty fact-sensitive analysis. But what I will go through is the overarching requirements. Most of you, or many of you, may already know that whether you do or do not fit this category. But if there are any questions, I urge you to please reach out to a VisaMadeEZ attorney or message us. So, what is the benefit of being an H-1B CAP-exempt employer? You can do away with CAP limitations with the lottery, and you can file for a qualified employee for an H-1B level specialty occupation for anyone who qualifies at any time of year, which is great because there's no limit, there's no specific timeline, and then who qualifies as an H-1B exempt employer. There are three general categories of institutions that fall under the CAP-exempt employer qualifications. There are three main categories for H-1B CAP-exempt institutions: institutions of higher education, nonprofit entities affiliated with higher education institutions, and either nonprofit research organizations or government research organizations. Let's get into each category. For institutions of higher education, the criteria seems straightforward. Universities usually come to mind. However, they must adhere to Section 101 of the Higher Education Act. This mandates that the entity be either public or nonprofit. Additionally, the institution must admit students post-secondary education, possess the appropriate accreditation for post-secondary education, and provide programs that either bestow bachelor's degrees or at the least offer two-year courses that lead to a degree. Typically, universities fit these criteria. When it comes to nonprofit organizations, they must first align with the IRS nonprofit definition. Beyond that, they should have an affiliation with an institution of higher education. This is often seen with hospitals that maintain a nonprofit status and are connected to educational entities like universities. We've advised several clients in this category. The burning question for many is, what establishes the affiliation between the nonprofit and the higher education institution? For that affiliation to be recognized, both entities either must share oversight or governance by the same board or federation. The higher education institution could directly operate the nonprofit. The nonprofit might be a member, offshoot, subsidiary, or branch of the higher education institution. Or an official agreement could exist where the nonprofit furthers the objectives of the educational entity. Lastly, nonprofit research organizations, as defined by USCIS, are entities primarily dedicated to fundamental or practical research. This category often requires a meticulous assessment of the specific details associated with your institution. All right, I've outlined the prerequisites for nonprofit entities, educational and research organizations, as well as higher education institutions. The looming question now is, can a for-profit entity be considered a CAP-exempt employer? The encouraging news is that they can, given specific criteria are met. Typically, we observe this in situations where a staffing agency deploys workers at a hospital affiliated with a higher education institution. The stipulations include the employer having an active service contract with a CAP-exempt institution. Moreover, the tasks undertaken by the employee from the profit-driven entity should further the objectives of the qualified institution. It's also imperative that the employee predominantly performs their assigned responsibilities in service of the said institution. With that, I conclude my brief overview. I trust this sheds light on potential eligibility and prompts further discussions on this pathway. The last thing I'm going to discuss is direct placement versus staffing company. Let's get into the distinctions between direct placement and staffing companies. While my prior discussion on specialty occupation predominantly revolved around the direct placement model, it's crucial to understand the differences. Beginning with the direct placement model, a fundamental aspect I hinted at earlier is the pre-existing department requirement prior to recruiting an H-1B employee. But why is this essential? At the heart of it, employers have a vision of creating a particular department or a specialized unit that comprises of nurses, preferably with BSN, under the H-1B category. The challenge is if your workforce comprises only H-1B personnel, the USCIS might perceive a discrepancy in hiring standards between domestic and foreign workers. Consequently, before integrating H-1B employees, the department must be pre-established. The motivation behind this is to present substantial evidence, emphasizing that this hiring isn't an attempt to circumvent H-1B stipulations, and that these nurses genuinely offer a superior level of service. Furthermore, while I've mentioned facility, it doesn't strictly denote a single location. An entity can have multiple health networks or sites, meaning your specialized unit might serve across different facilities. For intricate details on this, it's advisable to consult your VisaMadeEZ attorney. There are diverse possibilities, and it's ideal to explore them. On the flip side, considering the staffing company model, an advantage highlighted regarding the CAP-exempt model is the potential for staffing firms to leverage a client's CAP-exempt status, irrespective of the staffing company's own exemption status. However, the evidence to support this comes from the end client, not just for CAP-exempt status but also to demonstrate the specialty occupation requirement. Essentially, the onus lies heavily on the end client to furnish necessary documentation, underscoring the genuine need for the position. Similar to the direct placement model, the staffing agency isn't obligated to have a pre-established division for their inaugural H-1B nurse placement at an end client's facility. Still, the end client certainly must. As the staffing agency expands, it's plausible that they might also recruit domestic BSN qualified nurses. The core essence remains: the team serving a particular facility under the end client's mandate must adhere to those bachelor-level criteria. With that breakdown, let's address additional ensuing questions. This leads us into our frequently asked questions. As we have been working with various clients over the last few months, we've had a series of commonly asked questions that have come up. Addressing these questions will provide a clearer understanding of the process. A question we often encounter is, do only specialty nurses qualify for an H-1B visa? For roles such as nurse anesthetists or nurse practitioners, the requirement of a bachelor's degree, or in some cases a master's degree, is almost standard. These positions are unequivocally eligible for the H-1B visa. In fact, the U.S. government has affirmed this in their memos from 2002 and 2015. However, for positions that don't inherently necessitate advanced degrees, the onus falls on the employer, assisted by legal counsel, to demonstrate that the specific position mandates a bachelor's degree. We've observed instances where hospitals have specific nursing roles designated as higher tier solely due to the fact that incumbents possess a bachelor's degree, which consequently reflects in their compensation. Establishing such a trend can pave the way for a more straightforward H-1B argument. The second prevalent question is the H-1B visa affected by retrogression? The answer is straightforward: no, it isn't. Nevertheless, there is an annual cap for these visas. If a hospital possesses the appropriate affiliations, the cap can be circumvented. If not, the option to participate in the next H-1B lottery remains viable. Our third frequent question is, how long can the RN work on an H-1B? The standard allocation is for 3 years, with a maximum limit of 6 years. However, there's a potential extension opportunity. If there's an approved I-140 with a yet-to-be current priority date, the duration can extend beyond the typical 6-year limit. Lastly, we often hear, can you process EB-3GC simultaneously as a H-1B? The answer is yes. While processing the H-1B, the green card pathway can be concurrently established. Once the nurse has fulfilled the requisite time in the U.S., as stipulated by the employer, the green card application process can commence. Regardless of the nurse's location, be it overseas or within the U.S., the paperwork remains consistent. The primary distinction lies in the location of the interview. Can you hire nurses from any part of the globe via the H-1B visa? This is an exhilarating development. As many are aware, each country has a numerical cap in the green card process, capped at 7% of the entire allocation. When a country reaches this threshold, the visa bulletin presents a cutoff date, leading to retrogression. However, the H-1B visa doesn't consider the country of origin. It's only capped statutorily if under the H-1B cap. If a hospital system demonstrates its cap exemption, there is no boundary. This allows recruitment from countries like India and China, regions frequently impacted by retrogression, particularly for Indian nurses. Thus, the opportunity to integrate diligent and skilled nurses into your system becomes feasible. When considering global recruitment, this broadens your horizons significantly. Another common question is whether a nurse can bring their family to the U.S. Dependents defined as a legal spouse or unmarried with children under 21 can accompany the nurse. They'd be granted an H-4 visa. Questions often arise regarding the rights of these dependents, specifically about the spouse's employment rights and children's education. Addressing the latter first, children can be enrolled in schools shortly after their arrival. Regarding the spouse's employment, while H-4 visa holders don't receive immediate work authorization, they can apply for it once the RN secures an I-140. After its approval, which typically takes around 15 days, the spouse can apply for work authorization. Presently, this process takes approximately 6 to 8 months. An important note, USCIS has indicated potential premium processing for such work authorizations in the future. While not currently available, the anticipated change could reduce processing times to around 60 to 90 days. This expedited process would be a significant advantage for both RN and their spouses looking to secure employment. Now we have more questions trickling in. Do you wish to address some questions related to specialty occupation? Firstly, regarding the issue of hospitals not releasing degrees or transcripts of their employees, the ideal approach involves gathering comprehensive evidence for the highest chance of approval. If degrees and transcripts are not accessible, consider liaising with the HR department or department heads who can confirm employee qualifications. An affidavit or declaration from such individuals may serve as alternate evidence for USCIS. A question was raised about the eligibility of staffing agencies for H-1B cap exemption. Yes, a staffing agency can qualify for H-1B cap exemption if they place their personnel at a cap-exempt facility. The exemption is based on the placement location, not necessarily the cap status of the staffing agency itself. Regarding a staffing firm acting as a proxy employer for a cap-exempt system and potential co-employment issues, specifics matter. To answer that, for USCIS purposes, the actual employer is determined based on traditional factors such as who compensates the employee, who has control over hiring and firing, and who manages the employee on a day-to-day basis. In situations with intricate arrangements, it's critical to assess each case individually. Therefore, when a staffing firm is acting as a proxy, the H-1B petition must always be filed by the actual employer. A question was brought back came up about a potential return to the H-1C visa for nurses. Currently, there is no legislation reintroducing H-1C. However, our team is actively engaging with policymakers for potential changes. Another individual inquired if they could apply for H-1B while awaiting an embassy appointment due to retrogression. The answer is yes. The H-1B visa allows for dual intent, meaning one can still pursue an immigrant visa while on H-1B. Furthermore, questions about compact RN licenses from compact-recognized states have surfaced. At the moment, there is no legislation in place to reintroduce the H-1C visa for nurses. Nevertheless, our team has been in contact with policymakers to explore possible amends. Finally, an important note on petitioning a nurse currently on a B-2 tourist visa. No, given the B-2 visa's non-dual intent stipulation, It's not recommended to seek a green card while on this visa type. Doing so might contravene the visa's terms. Thank you. I'll address the remaining question about CAP-exempt organizations. Yes, a for-profit doctor's practice might qualify for CAP exemption if they provide consistent and crucial training for a university hospital and have an agreement with a qualifying organization. It's vital that the training is not just occasional, but regular and essential. Thank you both. One more question I'd like to address. If an initial H-1B visa is valid for just 1 year, can subsequent renewals or extensions be granted for extended durations? And what are the conditions for such extensions? Yes, after the initial 1-year validity of an H-1B visa, the first extension can be requested for 3 years. Any further extensions beyond that are dependent on the approval of the I-140. We appreciate everyone's participation. If we missed any inquiries, please reach out via the provided email addresses. That's all for now, and thank you. VisaMadeEZ, your career matchmakers, turning your dream of working in the U.S. into a reality. Experience our commitment to delivering results, not just promises.